Eric got involved. We were chatting over a kids' soccer game about how the MR program doesn't really have we have a law class. We don't have like a legal side mentorship program for us. So, you know, he thought it'd be great for their company to get involved, and Eric ended up being my mentor this year, which I really appreciate. Ended up offering to come and kind of teach a little bit and talk and discuss things. And Keith said he'd be out of town this week, so it worked out perfect. Just a little stuff about Eric. I pulled it off the website, so I think it's legal. Mr. Robinson is a member of the firm's, this is from Permaconti. Mr. Robinson is a member of the firm's Real Property and Land Use Planning section. He represents clients in matters related to financing, acquisition, planning, and zoning, development, entitlements, leasing, and the sale of residential, agricultural, commercial, and industrial properties. In addition, he represents lenders in documenting mortgage loans, as well as major landowners in property subdivision, developing governmental land use approvals, acquisition, and disposition. Mr. Robinson is recognized as one of Utah's legal elite and as one of the Mountain State super lawyers, rising stars for real estate. Another thing I noticed as far as experience involved in the preparation of real estate partnership agreements and the creation of homeowners associations. So, a lot of experience. So, further ado, I don't know if we'll go the whole time, depending on the questions and that, but I'll just turn it in. So, we give him this round of applause for being here.
Thank you. Yeah, it's a pleasure to be here. The professor asked me a couple months ago just to come chat about kind of some recent real-world experience I've had on the land use / development side. I've never been introduced per my website. I don't know if I need to update it or not, but some of the recent clients, the recent transactions that we've done that are less confidential, that are more public. I participated in the exchange between Kennecott and Suburban Land Reserve out in the Northwest Quadrant, Salt Lake County. It was probably the largest acreage transfer last year, a couple thousand acres to Kennecott. In that exchange, we represented Suburban Land Reserve on that. Represented Nitty-Grit Group, which is an industrial developer based here in Salt Lake. The principals are out in New York as well. We've recently purchased about 180 acres out of Syracuse and Utah Industrial Depot, which was a fun project. It's about 800 acres of a mess. Railroad, improved buildings, raw land, and lots of history, as you can imagine. Worked on the Shields building. Our firm represents the Lillenquist Group. We represent Transfuels, kind of an upstart entity that is buying, I guess, inserting itself in numerous gas station industries. It's LNG. So that's been a fun one as well. We recently bought their office building here and purchased numerous retail sites for them all across the country. A couple other clients we represent, Johansson Factory, here in Live in Bountiful, Costco's up there. They're now getting into hotel development. Hamilton Zans, based out of California. They kind of went quiet during the downturn, but they're doing a lot better now. They purchase low-income apartment buildings, roll them into TICs, tenant in common, and sell them as investments. They're starting to pick up again. We represent a couple of the Sorensen leftover children, and you know, many other players in the real estate industry. And by the way, you're here to hear something beneficial. If you have any questions, I don't mind if you need to leave early. I know it's a nice day out there. I'm not your professor. I'm not testing you on any of this. So just so I don't waste everyone's time, hopefully you can get something beneficial out of this. So feel free to ask questions throughout. We'll have a question and answer period.
On that note,
Feel free to go, Roger. I've worked with Roger a little bit as well over the years. I started in 2004, so I'm coming on 9 years here. And I only do real estate transactions. I don't do litigation. Our real estate group's been lucky enough to stay really active and busy throughout the whole downturn and beyond, due to some of our substantial clients and other benefits. So that's all we do are transactional type deals, land use deals, and development. And so with that being said, I prepared just a couple different situations, some common things that we see in transactions. We'll just talk about them. I assume, how many here are, I understand it's about split 50-50 to real estate development and land use planning. Who's in the land use planning side? And development side? Okay, developers are all on the fringe here. It's usually the case. Get in, get out, make their money, right? Okay, well hopefully we can find a good balance between the two. The first page, I wanted to give you a little background. So I gave you two provisions. One's the city code provision. The next one is the Utah code provision. So you guys probably discussed, maybe not, the Utah code is the enabling act for cities to enact their ordinances. So if they're contrary to the Utah code, they're not valid. So the Utah code gives cities the ability to enact their ordinances. And when reviewing city ordinances, it's important to make sure they comply with Utah code. Because if they don't, then they're not binding on you as developer. And land use planner needs to comb its city ordinances to make sure they're compliant as well. So in a recent deal, our purchase contract required, we were buyer, required seller to convey all water necessary to the city, or that was required for subdivision plat approval. Does all that make sense? I'm trying to gauge your background. So our purchase contract, seller says, hey, we're not going to give you all the water that we've been using on this property, but we will give you what's necessary for you. It was an agricultural property. What's necessary for you to record your plat and develop. Up to 3 acre feet. We look at the city ordinance. Well, that's fine because they already maxed it out at 3 acre feet. That's the measuring stick for water. We won't get into the math because I don't know it, but it's 3 acre feet of water. And so us as buyer, we said that's great. That's all they require anyway. Day before closing, and this is a big transaction. The day before closing, seller's engineer gets a hold of this. And we as buyer, we were buying, and then the next day we were immediately, I don't want to say flipping, but we were selling a portion of it. We were recording the plat and selling a portion of it to a large operation, about 30 acres of the 180. And so we were recording a plat that next day. So we needed seller to convey 3 acre feet per acre of the 30 acres. Seller's engineer gets a hold of this and says, whoa, whoa, whoa. That's an astronomical amount. We as buyer didn't care because they had a contractual obligation to convey that to us. I mean, when I say astronomical, we're talking probably $1.5 million worth of water that is an overage that the city was asking for. So, a lot of money. Seller's attorneys picked up on this Utah code provision, which states exactions. So, it basically says, you as city can't require more than what you need for this development. And if you are, it's an illegal exaction of water. We were able to, at 4 o'clock, right before recording, seller was able to negotiate with the city about a $1.5 million difference in water value that they did not have to convey. They recorded our plat, and we went on our merry way.
That was Syracuse, right?
Yes, Syracuse. There's other. We'll talk about Syracuse a little later. That was just recent. And that's why I point this out. Cities recently have been hoarding water. And there's been new legislation regarding that requires them to, not only this legislation, but if they don't use it within a certain time, they have to give it back and other things. So the reason why I put it off to pay attention to requirements. There's numerous plat requirements when you go record your subdivision plat that subdivides the property into numerous lots. There's bonding requirements. They're going to ask the dedication of numerous property, and many other things. If you don't pay attention to the details, you could get burned. We as buyer were ready to just convey it. We didn't care. The seller had the obligation to convey it. We were never taking title. But seller caught that and was able to save a substantial amount of money. Any questions?
So the seller sees that you guys don't need that much. Is he looking just after his own rights? Because you guys just said you only need what's required.
For sure.
of the development.
We didn't care. It's his money. He only had a contractual obligation to convey to the city, not to us. And which was a good provision for seller, right? Because they knew they had an overage of water on that property. The problem was they didn't pin down the amount until closing. At 3 acre feet, and I forgot one key fact. 3 acre feet probably is a reasonable exaction for a residential development where you're having landscaping, lawn, those. This was an industrial subdivision, right? And so, unless it's the NSA building down south, we don't need a lot of water.
So my question, I guess, is were you guys, how much time were you willing to give them to negotiate with the city on a different amount? So you guys are ready to close, record the plat, and move on, and it's in the waning.
I told them.
Deal.
There's a couple other moving pieces. Our other piece that we were selling was a 1031 exchange. You guys know what that is? Where some people don't. Where it's a tax benefit. Our buyer, so one buyer removed, was exchanging out of property. So it was selling a piece of property, using those funds to buy a new piece of property. That's a tax-free event if you exchange the property, basically. 1031 exchange. So it was tax. The issue was their hard date was the next day. If they didn't get that conveyance, it was like a $2 million swing on their end. And so we told them you have till this time, or you have to convey it. But stars aligned, and it worked out. I think what would have happened is they would have conveyed it under protest. I don't think it. Even let's say a city says now, go pound sand. They'll convey under protest, and then they'll work out afterwards, and the city would reconvey. That's what would have happened. It's a good question. Any other questions?
Yeah, this might seem like a dumb question. So they're buying the land, but they were holding back those water rights?
Yeah, they were.
Or they're
Water
selling
rights,
land?
they were water shares. They were
Water
irrigation
shares. Oh,
Yeah.
okay. Okay, that makes a little
But you can also sever water rights. We do that all the time. There's two different strains of water in Utah. A certificated water right, which is through the state, well right to pull a certain amount of water out of a river. And then there's an irrigation share where you have a right in a company that has a conglomeration of water rights. So these were shares. This is more governed by corporate irrigation. The difference is, it's good to pick up on that, is irrigation shares aren't necessarily tied to a piece of property. And so this seller, even though it's selling the property, could use those shares on a different piece somewhere else or sell them in the open market. Whereas a water right, it's a little harder. You'd have to go through a process to move that right somewhere. So it's a little more difficult situation. That's a good question.
I'm getting into it more, but
When you say water shares, are there different degrees of water shares, like better quality of water, it's a higher price? Or
Yeah, for sure. Yeah, it depends on supply and demand, but yeah. These ones were worth a lot. Yeah. And because the reason why I say that is because the water basin was long, coming out of a larger area, and so they could move. It was a bigger market for those shares.
The water right originated in Park City, and if you could take the water right and then transfer them upstream to the Park City, you could sell them.
So the water right, the irrigation was very valuable. Yeah. So I would say Weber River is valuable. Out in Tooele is becoming very valuable water. So that's a very scarce. It's gonna become more and more valuable as we become scarce. Any other questions on that transaction? You can divulge anything that's not confidential. Okay, let's move on. Oh, sorry. You bet. There's one extra in that bag. This transaction, I'll give you the background to it. Our client actually didn't end up purchasing it. A large portion of the south end of the valley. We'll leave it at that. Huge development. Our client was out of Texas. Very well-financed developers, had developments all over the country and internationally. And was buying this project at a killer price, supposedly. They didn't end up doing it, so I guess it wasn't that good. There were numerous title exceptions. Is that term title exception? Are we on title insurance? So when dealing with real estate, give you the background of title insurance, just the Cliff Notes version. You buy a piece of property, most people, you should buy title insurance. It basically says once you buy it, that you own it, and title company will defend any claims against it, except for, and then it lists title exceptions. So title exceptions are things that will hurt your ownership of the property. Things that were recorded prior to your ownership, and that the title company says, we'll ensure that you're the owner, but if some claim comes because of this document, this, that, or this, these exceptions, then you're on your own. We're not covering you under those. And so this particular property had numerous mineral exceptions. When I say mineral exceptions, the mineral rights, similar to water, mineral rights can be severed from the property. Meaning, the person who actually owns the fee simple portion of the property, owns the property, may or may not own the mineral rights. Very common, especially out west. These guys being from Texas were very, very concerned about this, because Texas mineral rights is king. I mean, they're actually from Houston. You could have anyway, nothing protected you against the guy who wanted to drill for his oil. In Utah, it's a little different. Mineral rights are still the dominant estate, meaning mineral right holder will trump the surface right holder.
Wow.
You own a piece of property and the guy wants to come and do something on it. He waves his mineral right deed or conveyance document. You got to let him on there. Now, the first paragraph talks about that, but he's got to be reasonable. You can't just come, tear down your house or, completely obstruct your agricultural operations because he upholds this mineral right. there's got to be some sort of balance between the mineral right holder and the fee simple holder, the surface holder. It's very common. Most of the west of Salt Lake, most of Utah, the mineral rights have been severed. And in every patent deed, and every deed from the United States to the first original owner, the United States has reserved the mineral rights. It's very rare that the mineral rights haven't been severed up to this date. There are obviously exceptions. So it becomes an issue when you're wanting to develop a residential, large residential development. How do we protect yourselves if you're buying this? What are some ideas? I've put the county and zoning laws protect you. What are some other protections? You could go to the mineral right holder, and they can convey their surface rights. We do that a lot. Where they say, yeah, we hold the minerals. We're not going to convey you the minerals. We'll convey you. We'll tell you we won't go on the surface. We'll just operate underground. There's other ways. Title insurance.
Endorsements.
Title insurance endorsements. Most of these, I think these two deeds, one was 1918, and the other was in the 20s to individuals. So it's not really practical. First of all, if we could track down the person, we wouldn't want to let them know they have rights in our property anyway. Most likely they obviously would want some money to release those rights. So it just wasn't practical to track them down. On this particular piece of property, there was a master development agreement which set forth the zoning, which are becoming very popular on large tracts of land, where the city and developer enter into this huge agreement where the developer agrees to construct all the infrastructure and do all X, Y, and Z, and the city agrees that you have this density and you can use the property here this way, and you can use the property here for retail, and it sets forth the zoning. Developers like it because they can show it to a lender and show their costs, and they have some sort of certainty on the infrastructure, the requirements of the city. And cities like it because they also have that certainty, and the zoning is then established through that agreement. And this agreement prohibited mining activities. So zoning protected us.
I have a question. I'm not be able to answer it, but between the mineral rights and subsurface rights, where's the line there? Because if I have subsurface right, if I have surface rights,
They've got to leave the property, I don't know the legal term, in a state that will remain developed. They can't mine to the point where the ground is falling. We usually leave it at 500 feet in our reservation.
okay, so I don't know if you're the surface owner.
There's no set.
Down.
So if we meant to attain a release of the surface, it would be 500 feet. But I don't think that, I just think it depends on, as far as a break point where it becomes dangerous, I think that depends on the geologist's opinion, on your geo studies. But yeah, 500 feet from what our guys say is pretty safe. That's what they tell me. Anyway. So moving on. So this had in the second paragraph, zoning protects you. Like I say, most of the western area, with Kennecott, obviously, most of the western portion of Salt Lake County is developed with numerous mineral restrictions owned by an active mining company. So fairly certain that they'll be that they're interested in the mineral rights. But most of the municipalities have prohibitions against mining. And as far as developers, we've developed a lot of substantial developments over these mineral reservations just based on zoning protections. Now, zoning protection is not foolproof. U.S. government can come in. There's a couple other things, zoning, let's say they find a valuable whatever, the zoning can change. But you're in a residential district, you're in, established area, it's not likely that that's going to happen. The other issue is non-conforming use. Have you guys studied that? So what is legal non-conforming use? Can you give me the definition?
One that's been grandfathered, that was existed prior to the
Existed
establishment.
prior to the zoning ordinance. Yeah. With mineral rights, it's a little different. And so what happens with that non-conforming use?
Usually it continues unless there's.
You still have the legal right to use your property in a non-conforming state. Except it changes. You can't change your use, right? And in mineral rights, the doctrine of diminishing asset, anyway, irrelevant, but the non-conforming use can expand. Because if you were just limited to this section of land, the mineral right. So if there was mining activity already on this property, that was concerning to our client. And so that's where that second paragraph comes from. The other issue you need to be aware of, as far as non-conforming, if it's a building and your building is destroyed by casualty, you can usually rebuild that. Most statutes allow you to rebuild that to the state. So you can have, you're into the setback area 15 feet, or your density, there's a lot of legal non-conforming uses. Your density is too high. You have too many apartments, but it was legal, and then they changed the density on you. It's still legal, and if those apartments are destroyed by fire or earthquake, you can rebuild it to that non-conforming density under most statutes. But if you voluntarily change it, so that's how the cities work it. In 30 years, someone's gonna have to buy that, tear it down. When the structures become dilapidated, someone tears it down voluntarily. They then have to build it up to the existing zoning. So that's how it's said. Sooner or later, the property will be at the existing zoning. The other issue I'll come across are mining protection areas, and mostly ag protection areas are becoming very popular in Utah, where counties will pass a law, ordinance that designates an area as an ag protection zone. It really doesn't mean anything other than the neighboring property owners can't sue when the cows start to stink. They're in the protection zone. Or if it's really dusty because someone's mining, it doesn't matter because they're in a protection zone. As an owner, I don't think it doesn't really affect your rights unless you're conducting those type of activities as a developer, because you can voluntarily pull out of those zones, which we do quite a bit. So, as an owner, if you want to change the use, it's not a use restriction, it's more protection. Any questions? Well, vested rights, has that term been used in this class? I mean, that's a very real issue. We'll get back to the Syracuse. So, Syracuse City transaction, I want to talk about it first, the water rights. During the due diligence period that our client was looking at buying this, we were applying for these subdivision plats and other land use approvals. And this area was located in a redevelopment area that the city had organized and was subject to city council approval. And so we had to go in front of the redevelopment board and the city council to get our approvals. Well, they happened to be the same. The city council was the redevelopment. So we show up to the meeting, and Bruce Baird, does he teach in the MRED program or at the law school?
I don't think he teaches MRED. Who is it?
Bruce Baird. He's a pretty famous land use attorney. Probably pretty impressive. Anyway, he knows his stuff. He was on our side as well. Like I say, I only document transactions. He was kind of the pound the table, crack the heads open kind of guy. let everyone know they're stupid. And so we go to this meeting. The RDA meeting is first, and I don't need to get into the details. There were seven members, and the RDA is going to pass or reject our approvals. We think we've already got a vested rights argument anyway, because we fulfilled the application according to the existing zoning, and they have no right to deny us. You know, those get a little, you know, like any litigation, both sides may or may not have good arguments. We're pounding the table, we've got vested rights. We get to the meeting, the RDA board passes 4-3 after much discussion. And so our broker, yeah, he's high-fiving people, you know, typical broker. You know, yeah, just kidding. Some of you guys are brokers. You know, he's like, we get paid. We're like, no. The city council needs to hear it. He's like, well, they're the same people. So these people put on their city council hats, and somehow it gets rejected. Yeah, opposite vote. And so the mayor, who's really pushing for this development, stands up, obviously not part of city council, kind of, wait, maybe we didn't understand. Let's rephrase the question. And so they rephrase it in opposite. And if you've been to board meetings, someone proposes something and then someone seconds it and then they vote yes or no. So they rephrase it opposite. So a vote for yes is a vote for us rather than a vote for no. And or vice versa, I don't remember which way. But the question was rephrased to where the yes and no was a different response in favor of us. And they do it again, and it passes. So the mayor closes the meeting, we get out of there, we get approved. People are asking, what? You know, this lady's crying, city councilwoman's crying, felt like I betrayed my community. And it was bizarre. So we overhear a guy talking to one city council / RDA member. What are you doing? So this one guy is the one who's kind of been flip-flop. What are you doing? You realize you just flip-flopped? He's like, no. I said I voted no every time. I didn't flip-flop. Well, the question had changed. So he's no vote. I mean, in his mind, he was staying staunch supporter of whatever position he had. So land use planners, educate your decision makers. Let them know before and after vote. I sit on a board of adjustment for the city I live in, and we don't get many hearings for variances, but occasionally we'll get some. I vote yes to just see if we'll ever grant one, but there's no way you'll ever get a variance out of those people that are sitting on that board. You know, one guy, and this is a direct quote, you probably find it on the record. I was denied a variance for something back in the 50s, and no one is ever getting a variance out of that city. And he literally sits on the board next to me, and he's rejecting these people because he was denied one time. So,
Is he still saying it?
So you don't ever know what you're going to get from city council members, and they're subject. And to their credit, I think most of them are trying to strike that balance between developer and the good of the community. I mean, I don't want to speak. Some developers carry a reputation of doing what's right for the community, and some don't. That's one important thing you guys will learn as you get out in the real estate community. Your reputation will precede you. Real estate attorney, developers, we've got attorneys that, if they're on the other side, some of our developers won't even make the deal. They just won't even make an offer if they know this guy is on the other side. And so, your reputation is everything you have. Especially, Salt Lake and the Utah area is a really small community. Everyone knows everyone as far as real estate goes, and if you're doing some suspect stuff, it'll get out there, and either communities won't want you, other people, other developers won't deal with you. It becomes known real fast who to deal with, and this one developer we represent is being approached by numerous cities to come into their cities. Obviously, with the downturn in the economy, it's kind of turning back up. Needed and wanted tax revenue. And so they're approaching developers to come develop, they're looking for industrial and retail areas. And so the other is vested rights. If you guys already studied, you can just read it. That's just most of these anecdotes are memos that I've written to clients with information redacted. And so that was a recent memo. Any questions? Vested rights or anything else? Subdivision issues. What is the subdivision law in Utah? You can't split a piece of property without going through the proper subdivision approvals through the city. It's just as simple as that. You can't carve off your backyard and sell it to your son or your neighbor. Well, you could to your neighbor, but that's a side issue. Sell it to another individual to build a house, unless you go through the proper subdivision approval.
Unless it's 5 acres or larger in some communities.
No. Even then, it has to be for ag use. And it can't be for any other use. The two exemptions that are used regularly are agricultural exemption. Farmers a lot of times are changing property. We do it quite a bit. Exchange parcels, or split off a parcel and give it to neighbor, or vice versa. We can do that. And boundary line agreements. That's one creative way we found where you're dealing with large tracts of land that are one tax parcel, and developer only wants to buy a portion of it. You've still got to subdivide it. Now, if the developer owns the adjacent property, we can go to a boundary line agreement. And that's usually, in some jurisdictions, not even a land use action. In others, like if you're in the city, if you're in municipalities, you've got to get an administrative approval to do lot line adjustments or lot consolidation. Do you guys understand the difference between administrative approval and public approval? Administrative approval is really, it's a lot easier. It's the land use planner will stamp your action. And so we like to, our clients, for reasons we discussed previously about Syracuse City, we like to avoid any type of public meetings and stick with the planners, if at all possible. It's a little more certain on what you're going to obtain. I attached this survey. We also, I didn't rattle off the clients, but I do a lot of lending work. I specialize in purchase and sales mostly, but also lending due diligence. So some big lenders, Nationwide, Allianz, Allstate, American National, some big loans. And you developers, lenders are very particular. They've got a box to check, and if it's not checked, you don't get your money. It doesn't matter. This happened to be a charter school. I tried to redact all the information. I don't know if I did. Anyway, this was I also do a lot of charter school work. This was an existing charter school. They didn't get us involved until after they built, right? So we didn't miss this one. This building has been operating probably for about 5 years. You can see right in the middle runs their lot line. They're going to, they come to us, hey, I'll give you a little background on how charter schools develop. Anyway, there's a group of individuals that make a lot of money off these. And they build the building, lease it to a charter school. The charter school operates for 5 or 6 years, and then buys the building from them. Usually through government-backed bonds or assurances. And so there's two lenders involved. There's the government lawyers who are protecting governmental interests because they're backing this loan, and then there's a private lender. The private lender will loan them the money, but the government backs it if charter school defaults, the government then pays it back. These guys had, for some reason, built their school over a lot line. So they had been operating, they could have probably operated forever, no one would have cared until they go to get their loan. No one's ever going to give them money with that, on that, ever. We get to, so they're pushing real hard. It was, they had locked their interest rate already, so they had to close it within a 30-day period. Well, to get the lot consolidation, it takes more than 30 days just to process it through the city. It's typical. Usually most actions can take at least 60 and most likely 90. And so they lost their interest rate, but we ended up consolidating the lots, basically getting rid of the lot line and removing that easement. So subdivision issues are very common, especially with the large tracts of land and developing with developers. And frankly, we're actually, one developer just, in a meeting, we were negotiating a purchase contract, and we had told buyer he has to subdivide it. It was part of our larger portion. He was buying maybe about 20 acres, and then he had another option on another 20 acres. So he's buying initially 20 acres, but was tying up 40 of our acres. And told him he had to subdivide it. We don't care. When I say subdivide, I don't mean like individual lot subdivisions. He's just got to carve that off of our main piece so we can legally convey it. He said, no, I don't care. I don't care because I'm going to go into the city and I'm going to record a plat with 20 lots. And then I'll take care of it then. We said we didn't care. Although it's technically a violation of misdemeanor. How does the city enforce that? It happens all the time. Some of our clients won't ever do it. They will never illegally subdivide or take title to a illegally subdivided parcel. Developers do it all the time. Because the only enforcement mechanism is withhold your permits. Right? And so this developer didn't care because he's gonna go work with the city, and he's only gonna do one subdivision, and that's with his 30 lots or whatever he works out with the city. So he didn't care. Because technically they could bring an action. We've obviously drafted in provisions to protect us in case the city requires it, or in case they attempt to enforce it. But the only enforcement mechanism is withholding your permits. Now, if we go to develop, if he goes under, and we go to develop our remainder portion, and this has never been subdivided, then it's a problem for us, right? It's a problem when we go to get our money. And so you have to build in mechanisms to protect you as seller as well. But it is an issue. It comes up almost on every deal, subdivision issues. So pay attention. Any questions on subdivisions? Or lender requirements are very strict. Zoning due diligence. This is basically, depends on what buyer, if you're a seller, obviously you don't care. But if you're a buyer, what due diligence are you going to do for zoning? If you're changing the zoning anyway, there's not a lot of due diligence to be made because you're changing it. I mean, your due diligence is you're going to the city meeting and putting out feelers to city council members and others on whether they're willing to change their zoning. But the existing zoning is irrelevant because you're changing it. But all lenders on larger loans, I don't do a lot of residential, but all lenders will require a zoning letter if the municipality issues it. If a municipality doesn't issue it, sometimes they'll require a borrower's counsel issue an opinion to zoning, or someone else issue an opinion, maybe their own attorney. On the last page is a sample zoning letter. Basically, most cities aren't going to give you much. Salt Lake City will say your zoning X. We don't know of any problems, but there might be problems. Some cities will give you everything you want. You know, tell me everything about this property. I want to know if there's any assessments due, if they paid all their fees, other things. This is your typical zoning letter, and I attached it because it was a little more complicated. It dealt with the non-conforming use that they go through the analysis, sort of, and that's going to be about all you get from cities. But it's a box that the lenders require that you'll have to check before you have, and before you involve attorneys or anyone. I would get the zoning letter. And the previous pages, this zoning letter checklist. A lot of times we'll just send this, especially if a city is kind of open-ended about, yeah, we'll give you a zoning letter, but what do you want in it? We'll tell them we want, all this information in it. And like I say, most sophisticated cities are just going to give you a statement that this is in, this zone, and we don't know of any violations, but there might be. But you can pin down a lot of cities to state in a letter what they will then be stopped from arguing at a later date, meaning they won't be able to argue that you're in violation if they stated something contrary to that letter. So, very important thing. Other issue or title. We talk about title insurance. It's a very important part of real estate transactions. There is what's called a title endorsement, or a zoning endorsement to the title insurance, which is similar to the zoning letter. And the title company, that's the other reason the zoning letter is important, sorry to jump around, is because the title company will require that to issue your zoning endorsement. And in a zoning endorsement, it basically says, title company ensures you, the owner, that this property is zoned this, that there are no violations. I always ask them, there are no violations of parking, density, setback, height, and building violations. And they'll usually give that to the zoning letter. They'll act like an insurer and take the risk with the zoning letter, and they'll give you that endorsement. But like I say, if you're changing the zoning or other things, zoning endorsements are pretty pricey, and sometimes it's not worth the cost to get it. But that's a standard endorsement I get on most of improved ground purchases. Any other questions? I was going to open it up to just general questions. You guys.
So I'm just kind of thinking through like the scheduling. If you're going to do a lot consolidation, can you be doing permitting at the same time, and you send in your plans, and they can be looking at the permit?
For sure.
So 60.
When you say permitting, like you're sending them your proposed site plans.
Mm-hmm.
Yeah.
So in a typical land acquisition deal, how many days do you put into a schedule for all the different things that you have to do if you were doing a lot consolidation and permitting?
I would say 60 days. Any city action, at least. And if you're going through a subdivision plat, the subdivision has preliminary hearings, then your approvals, and then sometimes planning commission and the city council. That's 90. I mean, it takes a little while. So your due diligence periods, they run from, most of the time you'll give them 30 to 60 days to kick the tires of the property. With an additional, once the due diligence period expires, your earnest money becomes hard. With a contingency, some sort of zoning change contingency or site plan approval contingency on the side, that you have to get that before closing. And if you don't get that, then you still get your earnest money back. So you become hard at this date for everything else but those approvals. That's how a purchase contract would be structured generally. It's the general rule. So, yeah, 30 to 60. I mean, obviously, we had one where we bought an office building from U.S. Bank, and they got a screaming deal, supposedly. I mean, he said the week after, I mean, he got an offer for a substantial amount more than we paid, so he did. But we had to close in 10 days. It's crazy. I mean, and typically you want, you know, especially in an office building, you want an inspection report. You definitely want, no, I'm getting off into other stuff with land use, so if you're bored. You want a phase 1 environmental, it's absolute must, geotech, and title / zoning. So that's a lot to happen in 10 days on a huge piece of property. But they bought it, they love it, and hopefully I don't see them again. You know, if I do, I screwed up on something.
Hey, so sometimes we were in your office, you were talking to developers and that, and you give them advice.
Yeah, being a mentee, I mean, you get to see me talking on the phone, that's about it. There's nothing too exciting.
But when you're talking to them, you're giving advice saying, hey, this is what I'd recommend, and they're saying, no, I don't know. So developers here, what things have you come across that is a common thing that a developer is not heeding your advice, that you're like, oh, that may catch up to you? And it hasn't.
Subdivision issues, they just basically said, I don't care what you say. I'm just going to do it. Title issues, you just take the risk. Some of them phase 1 issues. Now, phase 1 is an environmental site assessment. I'll just give you a background of that. That's required by CERCLA to have a defense against liability. If you're an owner of a property, you're liable for any contamination. It doesn't matter if you cause it or not. You could buy, you know, a piece of property tomorrow. If it was contaminated in the 50s, you got to pay to clean it up. That's the law. There's nothing around it. Unless you get a phase 1, and the phase 1 comes back clean, that gives you kind of your get out of jail free card. And so some developers, like, they don't have time, or if there's like, this has been a farm for 30 years, I'm not even worried about it. You know, it's a cost benefit analysis. But I always, it's probably the cheapest insurance you'll buy, because they're pretty, I mean, they're $2,000 roughly, depends on how big the property is. And it's if it comes back to bite you, you're sunk for good. So, I mean, environmental contamination, I mean, you're looking at a minimum, $100,000, just to look at it. I mean, just to even start, like, assessing it. So, that's a huge, huge issue. Other things, improvement agreements.
What are you saying if you get the phase 1, it comes back clean, that you got a jail-free card? How does that work?
Because you've done your reasonable due diligence on this, and you've relied on this environmental professional, and you're not liable to clean it up. It's a defense, it's a statutory defense against certain liabilities.
So who's the government responsible? Who's responsible to clean it up if you're not?
They'll go after other people. You as an owner can go after other people. Like the government can sue you, especially if you have deep pockets and you're the owner, you're going to get sued. And they'll say, you clean it up, and then you as the owner can go after the other people. Like we're dealing with one that's just ugly. I mean, real nasty. And everyone's got them, I mean, it's 1950s. We've got one previous owner we can go against, and that's it. So it's a huge deal. I just would always get that.
Do you have to get all the lawsuits resolved before the cleanup can start?
That's a complicated question. I mean, no. You're dealing with, you can enter into the voluntary cleanup program and voluntary cleanup and begin that process. And then a
tend to get contribution from your other entities. So no, you can clean it up voluntarily, and then after a point, there's a trigger where you then have a statute of limitations to where you can come back and get them for costs. But no, you can clean it up and then go back.
But can the person that you're coming back say, well, those costs are excessive, I would have been able to
Yeah, I
pay
mean
up
that's
for
all the
less.
argument. But
That's just the
It's-
game you play, right?
yeah, and really the argument's going to be percentage of liability. How much? Because you as owner, the burden's on you to prove their percentage. That's really where it's going to come. And then I was going to say, improvements agreements. Those are very common where we represent a buyer who buying a platted lot, but none of the improvements are in. Roadways aren't in, utilities aren't in. And we're paying an improved price, but none of the improvements are in. And so escrow/improvements agreements are that's a very contentious negotiation between buyers and sellers, developers, and they're more developers selling to another party. So, and we get a lot of pushback. A lot of times, as buyer, I'll require at least 130% in escrow based off a cost estimate that's required to improve that roadway that provides access and utilities to our property. So I'll make them, we'll put in our purchase price, but they'll have to escrow 130% of the cost of those improvements. And then as they finish, they get funds released accordingly. A lot of people were like, I trust this guy, he's going to do it. We got burned a number of times when the market turned, like big time. So either we had the improvements agreement in place, the cost estimates were way too low. So, any other questions?
What's like the flip side? What's the most common mistake that cities make when developers or process?
I think just not knowing their code. Like, we'll go. I'm not working on this, but some of my partners are fighting land use, another land use action. So neighbors, anyway, it's a long story. But neighbor is going for land use approvals, and we're telling them they can't for numerous reasons, and just informing the city of their own requirements is, I think, the biggest thing cities make. I think one of the things, I don't know, honestly, I come from more of a developer side because that's who I'm advocating for, and so I'm a little jaded, like, really against cities. But I think cities sometimes live in that pie in the sky type mentality, where I think they just need to become more practical. Not necessarily, I don't think they need to cave because this developer needs to make money, but just, I think there's a good line you can, medium you can find where cities can work with developers, so community and developer get. Because if developers aren't making money, they don't develop. The city I live in, the city office is surrounded by this huge vacant field that the city has owned for 10 years, trying to develop this, the popular thing is the walking retail. I mean, the city I live in is just not going to happen. It's never going to happen. And so it's just going to sit vacant forever. Now, that doesn't say you need to come put in some box retail, development, but they need to do something. I think they just need to be a little more practical. But I'm jaded.
This is kind of parts from us. How did you get into what you're doing now? Where did you start out in school? Or what path did they kind of lead you to become a land use attorney?
So my second year, I clerked for a firm. My second year of law school, I clerked for a law firm, a small law firm. I went to University of Idaho, and they did a lot of. It was a reputable law firm. They did a lot of insurance defense, and I spent 1 month. We represented a huge factory, and some guy had been killed. I spent 1 month devaluing that guy's life. And so I just couldn't do it. And I like real estate. I always plan on doing transactional, but that clerk, and some people love litigation. I like transactional type. I like doing the deals. That's it. I knew I wanted to do transactional.
Was your undergrad in planning or something like that?
No, it was, and law school does not prepare you for real estate practice. So it was learning on the fly. Like I say though, our real estate section in our firm is very vibrant, and that's all we do. And so it was kind of training on the job. You know, I had some knowledge, but no, I wasn't as prepared as I should have been. Any other questions? Okay. You can come up and talk to me after.